I have a master's in psychology for 22 years. I've been a practicing lawyer for 32 years. For the last 20 years, I've had the opportunity to practice in the family law arena in these child custody cases. It has shaken me to my core, what I have witnessed. It has become my personal mission to contribute what I can to get this system headed in a different direction. I have met, with former judges to talk about what I've seen, what they saw when they were on the bench, and how the train came off the track. I have met with legislators and have meetings set up to discuss what is happening in this arena. It is detrimental to the kids. This is supposed to be about the children. It is not. It has kept me up at night. It has made me physically sick to see that our system of justice is being handled in this way. I have 3 points I would like to address. One, dual relationships. Psychologists, custody evaluators are functioning in dual relationship. The court appoints a neutral psychologist for custody evaluation. After the evaluation is complete, the psychologist then moves to an advocacy role. They receive additional money to perform as an expert witness in the courtroom. They, during court, huddle and meet with the chosen party and their legal team as any retained expert witness would. In the courtroom, when presented with evidence that was never made available to them during their evaluation, let's say a new witness, they refuse to take this in as a judge would, as any neutral would. Oh, I didn't know that when I wrote the report. Let me take this into consideration and see how this impacts, if at all, but let me take it in. There is a refusal to do that. It's a denial. It is a digging in of defending a position, which is not the role of a custody evaluator. It is the role of a paid expert witness. These two roles have morphed. It is wrong. It is no wonder to me. I've never been in a custody fight. It is no wonder to me that all these people are lined up to talk about this. The sense of betrayal that they feel from this dual relationship, I can't even begin to tell you the pain I've seen. It's wrong. As a lawyer, if we act in dual relationships, we are disbarred. And there's a good reason for that. Total breach of trust. I cannot imagine that there is not a rule within the psychology world that prohibits this. How could anyone who's been in the system not find that objectionable? How could they not feel that the system had failed them, that the court-appointed psychologist had failed them? My second point, flawed work product. Again, my observation has been that the child evaluators fail to remember what their job is. Instead, what I have read are reports that act as the finder of fact. That's not their job. Their job is to report what they have learned. It is the judge or the jury's job to decide in a he said, she said, whose truth are you going to believe? If this turns out, this is what this party said. If that turns out to be the fact, then I would recommend custody in this fashion. Instead, they don't adopt that role. They again act as an advocate, picking a side in very black and white terms, which concerns me greatly, the polarization. And everything that is ascribed to one party is painted as true. You can take everything I have seen in a report that this party says as truth. There is no barometer that we as psychologists have that says this person is, their veracity is better than this person. There's no test to administer. Nobody's giving lie detector tests here. That is not the role. The role is, this is this party's perspective, this is this party's perspective. Should the judge or jury believe this, then custody should follow in this fashion. I'm sorry, this is my volunteer pro bono mission now to write this system. It is so destructive. Most disturbing of all, I have seen selective use of psychological reports in history. I have observed psychologists' written work product to ignore negative scoring, ignore prior psychiatric diagnoses, ignore all poor indicators about one party, ignore diagnoses, historical diagnoses, histories of people being in treatment for mental disorders, not even mentioned. Only cherry picking the selective facts about the party they want to endorse for custody. In the same report, they'll talk about the other party in a very black and white fashion, not mentioning all the good qualities that the party has, only cherry picking the worst facts that they can find. Facts that aren't even substantiated. Very disturbing.
Was that you about on your third point?
I am. Fees. I'm on my last point. What starts as an understanding that the parties will be spending $10,000 to $15,000 for a custody evaluation morphs into an $85,000, $150,000, even $250,000. $250,000 for a custody evaluation is insane and asinine and outrageous. One would think that with such steep charges that the psychologist was investing a great deal of time with the parent and the child. Such is not the case. In a recent custody evaluation, there was, in the time, less than 2 hours spent with 2 children. What was the bill? $84,000. This system's broken. I'm sorry to say it has been corrupted. I believe the judge needs to retake custody evaluation over because, frankly, we psychologists are doing a horrific disservice to the families of Texas. Thank you.
David Naylor.